Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 148 and section 292B. The name of the case is Principal Commissioner of Income Tax versus Tata Sons Limited, and this case has been reported in 449 ITR at page number 166. The matter has been decided by Honorable Supreme Court and the date of the judgment is 6th September 2022. Friends, in my various videos, I have said one thing, that there is a lot of importance of procedures in Income Tax Act. If any order is passed without following the due procedure, then whatever the outcome is coming out of that procedures, that is mostly in the form of orders passed by the Income Tax Department, those orders are not valid in the eyes of the law. Although we have seen that our high courts are remanding back the matter where the assessment orders are not passed with the follow-up of the due procedures, but in some cases even the remand back do not do the right justice to the assessee. So in that cases, quashing of the orders from the scratch are done by the courts. This is one of the example which we will discuss today. In the present case, the notice under section 148 was issued to the assessee on 6th March 2009. When the assessee asked the reasons from the department supplied the copy of the reasons to the assessee, and the assessee came to the feeling that the reasons have been recorded on 19th March 2009, that is after the issue of the notice. Assessee challenged this by filing the objections to the assessing officer, but the assessing officer was not convinced with the objections of the assessee and passed the assessment order in due process of assessment proceedings. Assessee filed the appeal to the CIT appeal by taking the ground that the notice has been issued before recording the reasons. That is why this notice is null and void and the assessment proceedings consequent thereto. CIT appeal examined the records and was convinced with the viewpoint of the assessee and quashed the assessment order. So the department filed appeal to the ITAT. The matter was before the Honorable ITAT. ITAT called the assessment records and filed that the first entry was on 6th March 2009 when the notice was issued. So it was the conclusive proof that when the first entry of issuing the notice was there on 6th March 2009, it means that the reasons have not been recorded before that. So it was apparent, it was lucid from the records that the reasons have not been recorded prior to the issue of the notice, and the department also could not substantiate its ground that the reasons have been recorded before the issue of the notice. So the ITAT also upheld the order of the CIT appeal that in the present case, the notice as well as the assessment under section 147, 148 is null and void. The assessee filed the appeal before the High Court. High Court also upheld the order of the ITAT. So the department filed a special leave petition to the Supreme Court. The Supreme Court upheld the order of the High Court and said that in the present case, the plea of the department that section 292B is there, which is for the clerical errors, and it can help the department, but the Supreme Court said that section 292B is only for the clerical errors and it is not for the jurisdictional errors. In the present case, it was very much clear from the facts of the assessment records that the notice has been issued prior to the recording of the reasons, and the reasons have been recorded thereafter. So in the present case, the whole proceedings under section 148 read with section 147 were null and void. In the present case, it was upheld that section 292B will not come to the rescue of the department. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Tata Sons Limited, and this case has been reported in 449 ITR at page number 166. The date of the judgment is 6th September 2022. Thank you, friends.